Greetings, this is Attorney Welch again for the third recording about important concepts in criminal evidence. You may have heard the term modus operandi. Well, that's the method of operation. Another term you need to know is an open-ended question. That would be such as why? How did this happen? A leading question suggests the answer. Isn't it true you're in love with the plaintiff? But an open-ended question lets the person testify freely. Attorneys avoid asking the why question because that interferes many times with the theory of the case. Now to discuss direct evidence. There is a case where a witness testified that she was rained on and got wet when she got out of the car after the accident. Well, this is direct evidence that she observed it rain on that day. That needs to be compared with circumstantial evidence. A witness testified that she believed it had rained on the day of the accident, as the street was wet and there were puddles on the road near the car in the accident. Thus the witness inferred, you need this inference, from the fact that it had rained prior to the accident. This would be circumstantial evidence, which requires an inference, that it rained on that date. Evidence must be relevant, having a tendency to prove or disprove a fact at issue in the case, and it must be material. Material means you can look at the pleadings and the applicable law to see whether the evidence being offered relates to the case. Now, in terms of lay witnesses, in order for them to testify, they must have personal knowledge of their testimony at trial, and this is a true question. Sometimes the law permits affidavits or written statements or declaration to be submitted, but the witness must have personal knowledge and must be able to testify under penalty of perjury under the laws of the state of California that what they are stating is true and correct. They must date it and sign it. Some affidavits or declarations must be notified, must be notarized. So you must check the law in your applicable area. And there must be some foundation of time, place, and manner, and so forth. Now, looking at the other concepts in criminal evidence, there's the exclusionary rule, where after the police makes a mistake, all of the evidence is excluded. For example, suppose a policeman comes to your door and says, "We're here to search your house, ma'am." Well, unless he has a warrant or some probable cause and you do not consent to the search, if he comes in and searches and finds some hidden marijuana plants, well, they're excluded because he made a mistake. It's like the fruit of the poisonous tree. Wherever he makes the mistake, that becomes poison, and that cannot be used. However, if you consent, then the police can come in and consent. Let's say that in executing a warrant to search for and seize a gun, the officer walks through the house and he sees a bag of white cocaine or white powder on the top of the TV. The officer can seize the powder because he is operating in the course of illegal activity and the powder is in plain sight or in plain view, and there is probable cause to believe the bag of white powder is narcotics. That would be true and correct. While making a lawful traffic stop, The officer looks into the defendant's car and sees a sawed-off shotgun on the seat. A warrantless seizure of the gun is permitted under the plain view doctrine. That's true because that was seen in plain view. The Fourth Amendment prohibits the police from arresting the defendant in his home without a warrant in the absence of exigent or emergency circumstances, and that is true. Generally speaking, the risks that trigger the exigent circumstance doctrine include those stemming from hot pursuit of a suspect, risk of police or public safety, and the risk of destruction or loss of evidence, and that is true. When a building is on fire, firefighters may enter without a warrant in the name of public safety, and that is true. Your roommate cannot consent to a police search of your bedroom in the apartment. That is true. That is your private area. The landlord may not consent to the search of the tenant's property, and that is true. The wife cannot consent to a hotel room being searched which has been occupied by her husband and her girlfriend. That is true. Protections against warrantless intrusions into the home apply with equal force to a property rented, such as a hotel room or a motel room. That is true. You have your protections in those rooms that you rent. This will be the end of our recording number 3. So we will discuss more concepts on tape